Welcome to This Explainer. Today, we're diving straight into something really fascinating, the classical Islamic legal framework regarding borders, foreign visitors, and the concept of sanctuary. When we look at modern geopolitics, we generally just assume that concepts like passports, visas, and diplomatic immunity are strictly modern inventions. But as we're going to see in the source material today, classical Islamic civilization actually developed a highly sophisticated taxonomy for dealing with non-Muslims entering its territories long before the modern era. So, before we get bogged down in the heavy legal taxonomy, let's just ask a really practical question about how these ancient laws map onto modern concepts of travel and statehood. How does classical Islamic jurisprudence actually treat a foreign tourist, an aid worker, or a diplomat crossing its borders? You might be surprised to find out that the framework focuses intensely on the absolute sanctity of agreements and the unwavering protection of the traveler. To really get a handle on the sources, we first need to define a core concept: aman. Basically, aman acts as a foundational guarantee of safety. Functionally, it's incredibly similar to what we'd call a modern visa or a grant of diplomatic immunity today. When a person is granted aman, they are fundamentally and legally protected from harm while inside the territory. It's the absolute cornerstone of this entire legal conversation. Here is the roadmap for today's explainer. We'll be covering the 4 categories of non-Muslims: the right of protection, what happens if you enter without an aman, misapplied rulings, and finally, handling foreign troops today. Let's get right into it.
Okay, Section 1. 4 categories of non-Muslims, taxonomy to application.
It's actually amazing how well these classical terms line up with modern international law. The source text breaks down 4 distinct groups. First up, the muhayyid. These are citizens of a state that already has a treaty with the Islamic State. Think of this like modern visa-free reciprocal travel between allied countries. Next is the mustamin. These are citizens from non-treaty states who enter with an official aman, which works exactly like a standard passport and visa holder today. Then we have diplomats who enjoy total diplomatic immunity, provided they don't engage in disruptive activities, of course. And finally, the dhimmi. These are non-Muslims who hold permanent citizenship within the state itself. Moving right along to Section 2, the right of protection, a sacred covenant. All of this builds into an exceptionally strict framework for keeping visitors safe, and it demonstrates the severe theological weight placed on protecting foreigners. In this system, a visa isn't just a piece of paper. It has massive, literal life and death theological implications. Take this famous statement from the Prophet Muhammad. It establishes that harming a mu'ahid, which, remember, is a citizen of a treaty state, is an incredible sin. The text explicitly equates the violation of an international treaty, or a visa, with being barred from paradise entirely. And the really crucial point here is that protection extends way beyond just physical safety. Notice the specific phrasing in this quote: wrongs, violates his rights, burdens him, or takes something from him without his consent. Classical jurists, like the famous Maliki scholar al-Qarafi, interpreted this to mean that even speaking an abusive word or slandering the reputation of a protected non-Muslim is a direct breach of the guarantee of safety given by the religion itself. It is a completely comprehensive protection. Now, what's really wild is how this concept of protection echoes right into the modern day. According to contemporary scholars cited in the source, like Dr. Mohammed Khair Haikal, the historical treaties of protection, the dhimma, actually remain legally valid today. Basically, even in the absence of a formal, unified Islamic state, the descendants of those who originally signed these permanent citizenship contracts historically are still owed that exact same status and right of protection today. The contract doesn't just evaporate over time.
There's also this fascinating contrast here between temporary sanctuary and official state citizenship. The source outlines a very unique legal mechanism: an individual Muslim's aman. Get this. Any ordinary Muslim citizen can grant temporary protection to a foreigner or even a prisoner of war, and that guarantee is legally binding on the entire state. The whole government has to respect it. But, and this is a big distinction, this is totally different from permanent state citizenship, or dhimma. While an individual can grant temporary safety, only the state or the imam can issue visas or grant permanent citizenship rights.
All right, Section 3, entering without an amin, border edge cases.
So we know the rules when someone has the right paperwork, right? But what happens when a non-Muslim crosses the border illegally without an aman or valid visa? Are they instantly considered a threat? Well, the source points to the prominent classical scholar Ibn Qudama, and his ruling is surprisingly pragmatic. He argues that merely attempting to enter the territory peacefully and unarmed automatically entitles an individual to safety. If a foreigner is found inside the borders unarmed, the law just assumes they entered believing they would be safe. The source equates this directly to the modern international law concept of carrying a white flag. Now, of course, if they cross the border armed, that claim to Oman is entirely voided because that obviously indicates hostile intent. But what about an administrative error? Let's say a local official makes a truce or issues visas, but they actually don't have the legal authority to do so. Ibn Qudama states that if non-Muslims enter believing they have a valid aman, but the truce is actually legally invalid, they are absolutely not to be harmed. Instead, Islamic law dictates that they are simply safely deported back to their home country. This acts exactly like modern states operate when dealing with visa mix-ups or invalid paperwork at customs today. Which brings us to Section 4. Misapplied rulings and extremism. We now have to look at how these really meticulously debated classical laws have been dangerously distorted and misapplied in modern conflicts. The author of the source article notes that extremist groups have routinely completely bypassed the nuances we just talked about. Two tragic examples from the text really demonstrate this: the 1998 kidnapping of tourists in Yemen and the 2014 execution of British aid worker Alan Henning by ISIS on completely fabricated charges of spying. The source explains that these groups attempt to justify such actions by cherry-picking classical fatwas, legal rulings, that were exclusively meant for active combatants, and wrongly applying them to peaceful tourists and aid workers. The core of this legal misapplication is pretty straightforward. Fatwas pertaining to active warfare just do not apply during times of peace. The text gives a really helpful historical parallel here. During World War I, Britain executed 11 German spies at the Tower of London. Nobody considers that a violation of peacetime law. It was wartime. Executing foreign spies who enter without an aman during an active war is a recognized military ruling across the board. But applying those specific wartime rulings to unarmed civilians during times of peace, or when there's a treaty, that completely violates the classical Islamic legal framework. Finally, Section 5. Handling foreign troops today. So if tourists and aid workers are strictly protected, how does this framework handle foreign military and intelligence forces that are currently stationed on Muslim lands? Even if those foreign troops are viewed by the populace as totally hostile, the legal protocol is surprisingly rigid. According to the sources, any existing aman, like a military basing agreement granted by a current regime, must be respected by the public. Vigilante violence or breaking that covenant of safety is strictly forbidden. If an Islamic government actually wishes to remove these forces, their only legal recourse is formal, state-level expulsion and the official abolition of the treaty, not random violence. Let's look at two case studies that plot this difference perfectly. Back in 1998, prominent scholar Abdul Qadim Zelam expressly forbade vigilante attacks on U.S. embassies, despite severe geopolitical tensions and bombings in Tanzania at the time, specifically because those embassies held an aman. Contrast that with January 2023, where the government of Burkina Faso formally and legally terminated its military agreement with France, which resulted in the lawful expulsion of 400 French troops. One is forbidden vigilantism, the other is the lawful exercise of state sovereignty. This quote from Zelam really nails down the normative classical Islamic position. You honor the guarantee of safety absolutely unconditionally for whoever is already under it. You do not take matters into your own hands. Instead, the geopolitical response, whether that's expelling citizens, closing embassies, or removing military bases, must be handled formally by the state authorities through the proper legal termination of agreements. I want to leave you with this final thought to consider. If the protection of a foreign traveler, regardless of their faith, is treated not just as some bureaucratic visa, but as a sacred covenant bound to the day of judgment, how does that completely reshape our modern assumptions about travel, law, and diplomacy in historical Islamic civilization? We've just explored a legal system that was deeply, deeply concerned with the safety of the individual, proving that historical borders were governed by profound ethical constraints. Thank you so much for joining me for this explainer, and keep questioning what you think you know about history.